This video is a project of the Annenberg Foundation Trust at Sunnylands.
Good afternoon, Justices. My name is Alyssa Hinchman, and I also attend Sandra Day O'Connor High School in Phoenix, Arizona. My grandparents and great-grandparents were actually interned in the Rower and Poston camps during World War II. And I would like to know what are the most important things that we should know about the Korematsu and Hirabayashi decisions.
As you know, the Hirabayashi decision involved prosecution of someone for a misdemeanor who didn't obey a military curfew order. You have to be out of a certain area, they were near the coast, by 6 p.m., and he was alleged to have violated that. And the court unanimously sustained that conviction and order. And Korematsu was a very different case because it involved orders that sent to camps people of Japanese descent, although they were U.S. citizens, and held them in those camps for some period of time because they were considered potentially of danger to the United States because of their Japanese origin. That case was one where the orders were upheld by a divided Supreme Court.
So we look in that Ken Burns thing I was talking about. They show a man of Japanese ancestry who fought in the Nisei Battalion for the United States.
Early in 1944, the 442nd received its orders to head overseas. Tim Takuno from the Sacramento Valley was granted leave to go and say goodbye to his parents.
They gave us a 15-day furlough. So I went back to visit my folks at Topaz, Utah. As I entered the compound, the MP captain stopped me and said, "Sergeant, have you got any liquor in your bag?" I said, "Yes, I have a fifth of whiskey to take to my folks." The captain shook his head and says, "Sorry, Sergeant, no liquor allowed in camp." It's a hell of a war, isn't it? That's what he told me. Hell of a war, isn't it? I said, "It sure is, Captain. Look, you got machine guns on all four corners with live ammunition, and you've got the guards patrolling the perimeter. And here I'm going into combat with my folks behind barbed wire." I said, "Yeah, it is a hell of a war."
So how did this come about? And the answer is people were frightened. They were frightened.
They were members of Congress were very concerned, and afraid of an attack from the Japanese, from the Pacific side. And there was just an element of fear running through the country, which prompted the
But what about
legislation.
What about this court?
what about
the
the
one question
court?
I would ask there, when you read these opinions, is what is it that the court is worried about? What are they struggling with? They start off asking a question, which is an important question, but they didn't get it quite right, but it's a question that will be true right today. The Constitution is not a suicide pact. That's what Jackson said. So we have to admit that you can do things in wartime that you couldn't do in peacetime in respect to civil liberties. And that then led them to say, the majority, well, we're not going to second guess the military and the president, and that's what they think is necessary, end of the matter. Well,
you asked what the case teaches, but one of the things it teaches us is that in war, we sometimes take actions which are more extreme than necessary. In war, our judgment is blurred. In war, our fears are high. Now in California and Oregon and Washington, there are thousands of miles of coastlines, or over 1,000 miles of coastline. Many of the land holdings on the coastline were by Japanese because it was pretty scraggly. There was not a lot of water there. So there's a tremendous amount of land ownership by Japanese all over the coastline. California was terrified. We had 2 destroyers defending the West Coast because of what had happened to us at Pearl Harbor. One of the most important people in the history of the exclusion orders that were issued in Korematsu is pictures in this room. Earl Warren. What was Earl Warren in the year 1942? What did he do? Do you know? He was the Attorney General of the state of California. Became governor in 1943. And he was terrified. And he gave an interview to Walter Lippmann, a famous American columnist, represented really the establishment newspapers, and suggested that maybe the Japanese be excluded. This came from one of the great civil liberties justices in the whole history of this court. As Attorney General, he recommended it.
He regretted it later. And the one thing that concerns me is that in the Korematsu case, we were not detaining Japanese. We were detaining American citizens of Japanese ancestry. Right. And we are a nation of immigrants. And I think we are all Americans. And because we are of Japanese ancestry doesn't mean that we are Japanese. And that seems to me a very key point. And I'm not a bit sure that any court in this country would sustain that judgment in Korematsu today.
Well, in fact, Justice O'Connor wrote an opinion in a case called Adirond, in which she referred to Korematsu. Korematsu has a test. We can ask you about what the test it sets forth is. And just, I forget exactly your language, but you said it was a surprising, astounding, or most unfortunate result. So we have an opinion from this court, as was a majority opinion, an opinion for the court by Justice O'Connor, criticizing Korematsu. But the point is, war tends to blur your judgment. And courts sit in order to make sure that judgment is more clear. And as you know, there were, as Justice O'Connor referred to, there were dissents in Korematsu. And there was commentary at the time from law review articles very critical of this decision at the time. So there were some more sober, more thoughtful, more careful people that were against this at the time. At the time.
And my grandmother was interned in Jerome, Arkansas, and my grandfather moved to Colorado to avoid internment.
Both my grandmother and grandfather were both interned at Manzanar Camp, along with their 7 siblings, and they're all Nisei, second generation.
My question today is, since Korematsu was not overturned, is it still precedent today?
Well, of course, it's precedent. It's out there. And it hasn't been directly overruled, but it's been criticized greatly. And I don't want these justices to have to answer your question unless they really want to. They may be faced with it. But I'm retired, and I'm willing to answer it, and I would predict that it wouldn't be affirmed in the same way today. I think enough questions have been raised that we can expect a more critical look would be taken, but who knows?
Justice Black used a very important phrase in Korematsu, a test that he suggested. What did he say? How is he going to look at this regulation, this military order, which discriminated on the basis of race? Discriminated on the basis of race. As Justice O'Connor said, not citizenship, race. How did he say we're going to evaluate this? What was the phrase that he used? He said it must meet very strict examination.
Pressing public necessity were some of his words.
And he used the word strict examination, from which we get the word strict scrutiny. The odd thing is that this standard, strict scrutiny, which started in Korematsu, didn't come out in a way that protected the minorities. They used the right test, but they came out not protecting the minorities. Very, very odd.
But it's so touching today that we have in this room asking questions, young people whose grandparents, I guess it were, actually were interned.
I suspect what the court was worried about there is they're very much afraid of setting a precedent that at some future time the president will feel he cannot protect the country when it's really needed. So the answer to that, which I think today we would find satisfactory, was given by Murphy, one of the justices you don't hear much about. But he said there isn't a shred of evidence. So it won't take some tough decision binding the president. All you're going to have to say is you have to have some evidence that there's really a problem. I thought that ends up, looking at it with hindsight, as the most powerful opinion. So Jackson wrote a very good dissent.
Did the English have a problem in England? They were at war 2 years almost before we were. And they were very close to Germany and Austria. And there were many German and Austrian citizens living in England, and it's referred to in the opinion. What did the English do? They lock up all the Germans and the Austrians, put them in a camp? What did they do? Do you know? It's mentioned in the Korematsu, in the Murphy opinion, the Murphy dissent. They held hearings, individualized hearings. You're Japanese, you have Japanese parents, or you're German, you have German parents. What is your occupation here? Are you ready to support the English war effort? Could you fight against your countrymen? There's 75,000 people. The English held hearings, and their island was, they thought, going to be swallowed up by Hitler's army. And they had time to have hearings for 75,000 people.
And Great Britain doesn't even have a written constitution and Bill of Rights like we do. But they managed a little better.
I forget that, I think they ended up detaining 2,000 or something.
Because remember, they didn't, I think Brown versus Board of Education is relevant here. I assume you've read that or know what it's about. But this is now 10 years, 20, 15 years before that, and the country is filled with racial criteria. The South is segregated. And the court has never said that's unconstitutional. So if you talk about the British and the Italians and the Germans, they didn't lock up or send out of California the enemy aliens who were of German or Italian ancestry. It was those of Japanese ancestry. And that is a world that partly why I think we would never get, I don't think, and you keep your fingers crossed, but why I think we wouldn't get into that situation is that the cases leading up to Brown in the race area and the cases decided after Brown and what's happened to the country over 50 years has shown that it's one country. And the law embodies that assumption, which it didn't at the time of Korematsu.
Did your grandparents tell you about any of the laws that were on the books of the state of California in the 1940s?
Not really.
There were laws that Japanese nationals could not own land. It was right there in the law of the state of California. Racial discrimination for land ownership. So one of the things about your Constitution you can ask is, how does it evolve? Do we have some prejudices now that we can't see? Is there some injustice now that we're blind to? Our parents, Earl Warren, the people that lived in California were good people, but they had a blindness. Are we blind today to certain things, injustices? That's one of the reasons you read cases.
My question is, how do the Constitution and the courts decide how to balance individual rights and national security in times of war?
These cases have posed exactly those questions. And as we said at the outset, the other branches of government, the courts and the Congress, have been generally willing to give lots of leeway during times of war to our chief executive. And the judicial branch has been willing to give considerable leeway to both branches when war is declared.
I think that's the difficult question, because if you don't give enough leeway to the executive, maybe it becomes a suicide pact. If you give too much leeway to the executive, they'll do anything they want. And that might not be good, because they might cut everything in favor of security and against individual rights. So how can a judge who's sitting in a room like this and is not out there in the streets or in the battlefield or doesn't have the responsibilities of the executive, how can a judge know when the executive goes too far? Well, here, it's not a perfect answer, but we do have a mechanism. In fact, we have several. And the best part of the mechanism, though they get a very bad reputation, there's one group of people get a bad reputation with the public, and they don't really, well, we're prejudiced, but we think they don't deserve it as much as they get it, and they're very helpful. They're called lawyers. And the lawyers in a case like this will put the government to the test, because they'll say, representing the person who's injured or put into camp or wherever, they say, why? And they don't want a general answer, they want some evidence. And if the person whom they're talking to says, oh, it's too secret to tell you, they can always say, okay, tell the judge. Look at it privately so we can see if it really has to be secret. See? And if they say, okay, there really is a problem, the lawyer asks the second question, which is, why not? And why not is, why not do it this way, where maybe your client doesn't have to be put in the restriction, you just have to have a curfew, maybe not a curfew, maybe something less restrictive. Let's think of a less restrictive way to do it. The lawyers, with those questions, can help the judges decide whether the executive branch has really exceeded a leeway that they already have. Have they gone really too far in this instance?
How did Justice Jackson answer your question?
If I simplify that in my own mind very clearly and simply, I think Jackson's saying, don't worry so much about whether your rule, court, protecting civil liberties, hamstrings the executive. Stop worrying about that. If they feel they have to violate the law in order to save the country, they'll do it. So don't worry. They'll just violate the Constitution. Let them. That was 1942. The Army would have done it anyway. We should say it violates the law. Now that's in a very attractive position held today by a lot of civil libertarians. But it rivals another view. Don't put the president or the executive in the position of violating the Constitution or feeling they have to do it. Because ultimately they may make the wrong decision at the time and wreck the country, or more importantly, you will seriously hurt the rule of law. Don't say the president had to violate the Constitution, or a lot of other people might think it's okay for them to violate the Constitution.
We had Lincoln was sitting at the White House here in Washington, D.C. He was surrounded on 3.5 sides by Confederate troops and military action, hoping to take the Capitol. He was trying to bring new troops in to protect the Capitol from the north, and the railroad line went through Baltimore, Maryland. And there were 2 stations. The troops had to get off as they came south at one station and then go on foot to the second station to get to Washington, D.C. And they were being attacked by Southern sympathizers as they made that trek. Southern sympathizers were clipping the telegraph lines to cut off communications with Washington, D.C. And it was a terrible situation. And President Lincoln ordered that Southern sympathizers in that area be arrested on his orders. And the military started just arresting people, even prominent citizens. One of them turned out to be a legislator in Maryland, and had them held at Fort McHenry or other forts, and just said, keep them there till I say okay. And some of those people arrested tried to get a writ of habeas corpus in the federal court to have a hearing before a court on whether they could be held in jail without any individual suspicion. And the petition went to the local federal judge, who just happened to be the Chief Justice of this court, Roger Taney. Roger Taney was at that time the Chief Justice, and he signed an order saying, bring this person to my courtroom on date X, and he gave that order to the commander of the military camp. And the commander sent word back, no, because the president has ordered me to keep this man here in jail. And that was the position that President Lincoln took, that he would not obey an order of the Chief Justice to bring one of these prisoners before the court. And the president just went his own way on it. But he thought that the situation in Washington, D.C. was critical, and he didn't know if he could hold the nation together. And so it was a very different time, but it's a very interesting example of where a president defied an order of the Chief Justice in order to try to secure the nation's capital.
Let me ask you, does the president have the power to suspend the writ of habeas corpus?
Article 1, Section 9, it says, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. And Article 1's about the powers of Congress, not about the president.
Well, it doesn't say Congress, does it?
No, but it
Suppose
pertains
Congress
to
isn't in
Congress.
session. We know that the habeas corpus is not absolute in times of public emergency. In the situation that Justice O'Connor describes, President Lincoln comes to you, you're his attorney, and he said, now Congress isn't in session, I've got to do something. This justice wants me to bring a Southern sympathizer, who I think he is, causing tremendous problems, and I'm not going to, I don't have time to do that. I'm leaving him in jail.
I guess the president would have the right to do that because he would.
Well, now you're changing your mind?
I mean, I don't think the president has the right to do that if Congress is in session, but if Congress, it wasn't in session, I guess the president has the, I don't really know.
Well, the court.
I don't think anybody does. It's all right.
Don't know either. But you see the importance of consultation. You see the importance of the president and the Congress both being political branches of the government, cooperating, thinking, reasoning things out so that the Constitution is observed and protected even in times of great urgency. And Lincoln was very good about consulting, about writing, the reasons for what he did.
He felt guilty because he gave a famous speech, which you can look up. Don't, you can sit down. But you know, it was something along the lines of, "Shall all the laws but one go unenforced, so that that one remains in power, in effect?" As he was thinking, all the laws will not go enforced because we'll destroy the Union.
That's what he was thinking at the time that he entered that order.
That's right.
Are there rights that can be suspended in times of war, and if so, what are they?
Are there rights that can be suspended in times of war? Well, we've had a couple of examples already. The right to choose where you live and to live freely was suspended, wasn't it, in Korematsu for people of Japanese origin. And the right to get up and walk around freely wherever you want was suspended in Hirabayashi by a military order. So, you know, you've got two examples right in front of you, and I guess there are many others as well.
But you've just talked about habeas corpus, so the Constitution speaks about that. But the more normal thing, and this doesn't help particularly, but it is, I think, the more normal way that judges will think about this. A lot of words in the Constitution are quite indefinite as to their content. See, the Fourth Amendment, it doesn't say the policeman can never go into your house without a warrant. It says that the policeman cannot engage in an unreasonable search and seizure. The 14th Amendment speaks of liberty, but it doesn't quite say what that liberty is. The First Amendment says that Congress shall not pass a law that abridges the freedom of speech. But what is the freedom of speech? Now, if you have, in time of peace, a policeman who's on the street and he sees a woman being dragged into an apartment house screaming, is he going to stop and wait for a warrant? Well, I should hope not. And the law will support him in that action because it's reasonable given the circumstance. So in war, there often are new circumstances of a special kind. And that's why so often you see the judges asking, well, given the circumstances, is this limitation and definition, a limiting definition of a right, is it called for by these circumstances? A question that's very hard to answer often. And we say it's easy in Korematsu. They got it wrong because we're looking at it with hindsight. And we each would like to think, if we were there, we would have even written better dissents. That's what we'd like to think. And of course, the interesting thing about history is you never know, really, what it was like at the time. And that's why Justice Kennedy says, are there things going on right today that when people look back at us, they'll say, how could they be so blind?
Why are independent courts important?
Yes.
Because people have different opinions on different things, and you sometimes need to look at things from a different point of view.
All right. Now, suppose during war, because this responds to your question, suppose during the war the president said, I've got military courts, I want military courts to be in charge of this state, be in charge of this region. Is that proper? Civil war in the United States. I want military courts in Ohio. The rule is, do you know what the rule is? The rule is if the civil courts can be open, you must go to the civil courts. If they can't be because the enemy's in control or active hostilities are going on, then you can use military courts. So that's a balance that the law says ex parte Milligan is the name of that case. That's a balance that the court has come to. You can use military courts sometimes if the civil courts are unavailable. Reasonable enough.
I'll go back for 1 second because this is making me change my mind about something. What is the most interesting thing about Korematsu? Now, I think at the moment, having listened to this discussion, that maybe the most important thing about Korematsu is each of us thinks, if we had it in the court today, it's a racial criteria. a racial criteria. They didn't do it to the Japanese in Hawaii. They didn't do it to the Germans. They didn't do it to the Italians. And immediately red flags would go up a mile high. And you'd look back at that and say, oh my goodness, that really is, they have to have unbelievable evidence to sustain this, and they don't have any, all right? But now wait. This attitude you have in our minds and in your minds because of action people took in 1950s and 1960s and 1970s. And people in the country took the action to fight the racial criteria, and they changed not only the judge's mind, the judge's opinion wouldn't have lasted 5 minutes if President Eisenhower had not decided to send the 101st Airborne Division to Little Rock, Arkansas, where the governor was standing in the schoolhouse door with the state militia designed to block the entry of those black children. And you know why he sent the 101st? See, that doesn't resonate with you. You start talking to me, and those a little older even, about the 101st Airborne, my goodness, that was the division that went in on D-Day, the toughest airborne division in the American Army, and he purposely picked that division because of its symbolic value. And he wanted to say everything about America is in favor of the integration and following the law. Do you see? Now, it's him, yes, but it's also millions of Americans who were willing to say, I'm going to take this issue on. It's not just the judges. So I think I'd look at Korematsu and say to you who are in high school, read this history. Don't forget the history of the United States of America, because there were millions of people just like you who were willing to take on some of these issues, who were willing to fight them under law, but not just in the courts. It requires a lot of support to get those interpretations of the Constitution that we now have today. And as we all have said, this is ongoing.
I remember the outbreak of World War II. I lived in Sacramento, California. My father was an attorney. He had clients who were Japanese. They were on a remote, they were remote from the city. They were on a ranch, and I used to go out and play with the boy who was my age while my father was with his parents working out their problem. And one day he came to my house suddenly, unannounced, and he had his favorite toy. His favorite toy he could never touch. It was a little samurai warrior in a glass case. It was in his room. That was his toy, but he didn't touch it. And he was trying, tears came down, and he gave me the little soldier. And I'll never forget it. I knew something was wrong. I didn't understand what was wrong. But what was wrong was that he was being sent to a relocation camp. And my father, who was an attorney, was outraged by this. And so I knew this problem from a very, very young age, and I never forgot it. Fred Korematsu, is a study in courage.